Americans do not want to think about what happens when they pass away, when they die, when unfortunately they do not live forever, at least not yet. In a Harris poll, because we always believe in polls, it has been realized that more than 50% of all Americans do not have a will. I do not know the statistics in other countries, but in America, overall, 50% do not have wills. No estate plan in place, no trust, no plan for when you pass away. And in certain minority communities, 1 in 3 or 1 in 4 people have a will. So give you the overall statistic, and in some segments of the population, it's even more people, a higher percentage of persons not paying attention to what happened, not thinking about it. Why not? Well, at the outset, it involves a difficult conversation, a difficult thought process, coming to terms and to grips with your own mortality. Who wants to think of it? Well, my suggestion is, my counsel, my directive is that you think about whether it's difficult or not, uncomfortable or not, because you're not thinking about it for yourself. Because when you're dead and gone, mostly everything doesn't, except people keep on going, right? So your spouse could unfortunately be that they're, I guess that's a tricky thing, right? If I pass away before my spouse, it's boo-hoo for me, better for her. But how can I say, unfortunately, that the spouse outlived you, and that doesn't work, right? The point is, at some point, if I pass away before my spouse, she has to think about, she's the one with the problem, or it's not me, I'm somewhere else, not down below, I was gonna say in the ground. I guess it could be on a wall too. But if I'm not around, it's the loved ones that are left with the pieces to pick up, right? I don't want to be too melodramatic. I'm already melodramatic enough. But the plan allows a person to, your family members, your loved one, the people you care about, allows them to pick up the pieces seamlessly, effectuate a plan. That's what it has. Please think about that. A friend of mine wrote an article on leaving the original documents with your attorney. And it's because he had a cautionary tale where a person was going to leave assets to a specific individual. That individual did not reside at home, and upon the passing of the person, other family members, this is the accusation, allegation, contention, that other family members that had access to the home made that will disappear. I don't know if that's accurate. It's supposition. This person doesn't know it, but it at least is a reason for why you might want to have your original documents remain with the attorney so that they're in safety. And that's because in New York, there's a requirement that the original will be produced for probate. Original, not a copy. If you cannot find the original will, the presumption is that testator, the person making the will, destroyed, ripped it up, and didn't want to use it. Now, I received a call today from a client, a past client that I had done a will for several years ago, older person. She told me that circumstances have changed. Her given situation is that she is not presently married, has no minor children, so she is providing to nieces and nephews, friends, charities, and a number, and her circumstances change. She does not want to provide for the persons that she previously provided for. So I do not have original will. And she acknowledged that. I said, you left my office with the original will. Yes, I do. I have it. Yes, I did. I do have it. We didn't speak in that kind of click-clack talk, but she has it in theory. Well, in actuality, she could rip up that will if she really didn't want to give to person A, B, or C. That leaves her with no will, and as a person that's single, but a divorced person is considered single, a widowed person is considered single, a single person with no children, well then other relatives that she may or may not have an interest in providing for would receive money or benefit of her assets. But if she definitely doesn't want it to go to person A, B, and C, well, just don't have that original will anymore. It's not the best advice. It's practical advice. You can rip it up, then you have nothing else in place. And it's your money, your assets, your legacy, your bequest. So if you don't want to give to person A, B, and C, you're not required to. It's your stuff. Rip it up, but then make a new one, right? Give it to person X, Y, and Z, or this particular charity, or I don't know, your favorite cause, or real flesh and blood people that are presently in your life, that have deep meaning to you. Blended families, when done right, supply joy for all. But when you don't plan properly, they produce their own sets of difficulties and circumstances. Because if you have children from a prior marriage and you don't properly plan, well, what could happen? And what do I mean by don't properly plan? Well, there's layers of plans and levels of plans and an array of plans. If you have none, so you're at 0. If you have a will, you might be at a 7.5. And if you have a trust, you might be at a 10. So in this little story, 10 is good. 10 is really good. Well, if you have no plan, you follow the plan of New York State. That's intestate. And if a person passes away, their asset, any asset they have in their individual name, goes to their spouse and their children. Spouse and children receive. So now what happens if a person is married and they have children from another relationship? Still their kids. So if you own a house, that house goes to your spouse partially and to your children partially. But the spouse, well, that spouse may not want to have shared. I'm fracturing that sentence. Perhaps that spouse doesn't want to provide for your children. Or the reverse. What would happen if you have your name on the deed with your spouse, but you also want to protect your children? You need a plan. So what are the things to do to figure out where things are going to go and how you want them to go and what to do? Well, speak to an estate planning attorney. This guy. Speak to an estate planning attorney and let that attorney know what's good, what it is that you're looking to do. And then we can have a conversation about what would make the most sense for you and you. Speak to your family. Let them know. This is what I intend to do. I'm going to provide for my spouse for a period of time, and then the house is going to go to you children. I have money in a bank account that's going to go to children, and I want this other specific asset to go here or there, right? So speak to an attorney, speak to your family. Think about the plan that you want. Take care of, don't just set a plan, but then don't forget it. Don't forget to review it or look at it again. Periodic and frequent reviews of your plan make sense, either both with an attorney or on your own, just looking at your plan and looking at your family dynamics. Well, I was providing for this person and now we're not so close. So I want to remove that person or give that person something like that. And if you have minor children, name a guardian for your children, especially if they're children of a blended family. You want to make sure that they are taken care of. So those are just some of the things that I'd like you to think about when you have a plan. Thank you. So if you need assistance, FrankBrunoLaw.com.